May I please, my lady.
Yes.
I beg to mention item number 54.
Item
54.
number 54. Yes.
Yes.
Fixed for hearing.
Yes,
What
Ladyship,
happened?
I have some personal difficulty today, so may it be listed after 2 weeks. If it is convenient for the court on 2nd May.
Okay. What about the
I've taken the consent of
petitioners? Consent has been
Yes,
taken?
Lordship.
Yes. Heard Mr.
K. Angami,
K. Angami, Learned Counsel for the respondent,
state respondent.
state respondent, who has prayed for adjournment and mentions that consent of the petitioner has also been taken. He has prayed that this matter be listed on
2nd May.
2nd 5/2023. Praise aloud. This is matter on 2/5/2023.
Your Lordship, I'm appearing for respondents number 6 and 7 in WPC 128K. This has not been
Serial
listed.
number?
It's not been listed
Okay.
today, Your Lordship.
Uh-huh.
But on the previous date in this court, on 20th of March 2023, this court, with consensus of all parties, directed that the matter be listed today on 17th for final hearing. However, it's not been listed, and I'm an out of station, Your Lordship, and that was taken into consideration. The urgency of the matter was taken into consideration, and it was listed for today. It was supposed to be listed for today. If I may read the order, the previous order that records that it needs to be listed today, with your permission. As prayed for by the learned counsels for the rival parties, list this matter for hearing on 17/4/2023, on which date we shall endeavor to be made to dispose of this writ petition. Your
So what
Lordship,
do we do?
I'm seeking for the matter
Fix
to.
another date?
Your Lordship, I am an out-of-station counsel. I have to travel all the way from Hyderabad. This was the consideration that was also made when the matter was directed to be listed today. The matter is pending from 2020.
But what about the counsel for the petitioners?
Their consent was also taken. The date for 17th was fixed after going through the calendar and taking consent, as it's recorded that the rival parties'
Okay.
counsels have also consented for this date.
Anyone appearing for the rival parties today? Now, if none appears today, we cannot fix it today because they are not ready. You have come well prepared. But if no one has appeared for the rival parties today,
Yes,
we'll
Your
have to
Lordship.
fix another date.
If I can,
Give me a date where you can
Your
come
Lordship,
again.
tomorrow,
But we'll have to inform the rival parties.
I will take the responsibility of informing the rival parties, Your Lordship.
Heard Miss
Shreya Parupkari.
Shira Parupkari. Is it? Learning Council for respondents number
6 and 7, Your Lordship.
6 and 7, who submits that as per this court's order dated
20th March 2023.
2023, this matter was to be listed today. However, since this matter has not been listed today, she prays that this matter may be taken up tomorrow, that is 18/4/2023, since she is an outstation counsel and had traveled all the way from Hyderabad.
Yes, Your Lordship.
In view of the above, this court find it fit to list this matter on 18/4/2024. And on the assurance given by the learned counsel for the respondent, number
6 and 7.
6 and 7, that she will inform the learned counsel for the petitioners.
Your Lordship, if the date may be, I think I
Yes,
may have
yes,
heard
if
it
you-
wrong. 18th March 2023
Yes.
listing.
Yeah. No, this is April, isn't it?
Yes,
Oh,
April, sorry. I
it's
thought
four,
Your Lordship
four,
said
four,
2024, so I was confused.
Okay. In view of the above, list this matter on 18/4/2023. Yes.
Much obliged, Your Lordship. Thank you.
May I please, Your Lordship? My Lord, I beg to mention item number 17.
17. Yes.
My Lord, I'm here to receive instruction, so kindly allow me 3 weeks' time.
Heard, Mr.
My Lord, item number 46, not
I
17.
thought you said 17.
Yes, my mistake.
46.
46, yes. Ma'am.
Heard Mr.
E.T. Paphom.
A.T. Bapom, learned government advocate.
Yes.
May I please, Your Lordship? I have an objection for that.
Why?
On the last occasion, they were given time to obtain instruction.
Is
This
that
is
one?
regarding what?
Regularization,
Instructions?
my lord.
Yeah,
So,
but-
my lord, I'm
for
here to...
pension, Your
Yes,
Lordship.
I'm here to receive instruction, my lord.
Yes.
Your Lordship,
I will mention the objection. Okay. Heard Mr. So-and-so, learned government advocate for the state respondents, who has prayed for adjournment of the matter, stating that he has yet to receive instructions from the state government. Miss
Limanaro.
Lima Narum, Lima Naro, okay, learned counsel for the petitioner, has raised objection, mentioning that the state respondents were given time for receiving instructions even in the last court date. However, this court find it fit to give another opportunity to the state respondents for filing their, or for getting the necessary instructions in this matter. List this matter after
3 weeks, my lord.
3 weeks.
Much obliged.
Yeah, Mr. Lordship.
Yes.
Lordship, I beg to mention item number 20 to 37, Lordship. Lordship, I was appearing for respondent number 5 in this case, Lordship. The Nagaland Lokayukta. Lordship, I'm no more engaged by the Lokayukta. So my name may be deleted from the cause list, Lordship.
What is the stage?
Lordship, here I have instruction to appeal for the respondent number 5, the Nagaland.
Okay, Lok Ayukta. Okay.
Lordship.
Uh-huh.
So,
But you'll have to file a
yes,
PAR, isn't it?
Lordship.
Yes.
Power and to file affidavit, Your
I would
Lordship.
require affidavit.
Like the 4 weeks time may be given to me. His name may
Okay.
be.
In the meantime, my name may be deleted.
Yes. Heard Mr. N. Mozu, is it?
Yes.
Who appeared, who mentions that he is no longer appearing for the respondent number 5, that is the Nagaland Lokayukta, comma, while Mr.
TB Jamir.
T.B. Jamir, learned.
I'm just engaged counsel.
Okay, while Mr. Learned Counsel mentions that he will be appearing for respondent number 5 and will be filing his PAR shortly. Okay. Miss
Viketsono.
V.K.
Viketsono.
Chaman appears on behalf of the petitioner. In view of the above, list this matter after 4 weeks.
Lordship.
Obliged.
May I please, Lordship?
I have a similar prayer, Lordship, on item number 47. Here I'm appearing for respondent number 3 and 4, the Office of the Accountant General, Lordship. Lordship, I have received the instruction and the affidavit is under preparation, Lordship. So if 2 weeks may be granted, Lordship.
Item number 47.
47. Respondent number 3 and 4.
Heard Mr.
And
N. Mozu, learned counsel for respondent number 3
3
and 4.
Lordship.
Who
Lordship.
mentions that
None of the respondents have filed their affidavit in opposition, Lordship.
he has received instructions and has prayed for time for filing of his affidavit in opposition. Anyone else for respondent?
I for the state. I'm mentioning on behalf of the Inaholi. The state
Miss?
needs to receive instruction. Inaholi.
Nahogati appears on behalf of Mr.
I'm appearing on behalf of Miss Inaholi. Inaholi.
appearing on behalf of Mr.
Miss
Inaholi.
Okay, Miss
Inaholi.
Inaholi
The state are here to receive instruction.
appears on behalf of the state respondents and has prayed for time for filing of their affidavit in opposition. Mr.
CD Rungsung, Lordship.
C.D. Nungsung appears on behalf of the respondent.
Petitioner, Lordship.
Yes, on behalf of the petitioner. In view of the above, list this matter after, how long will you take? 3 weeks?
Yes, Lordship.
This is matter after 3 weeks.
Lordship, the petitioner is a senior citizen. If they can fasten the process, it will be.
3 weeks' time, let's see. Yeah.
Lordship.
Yes, after 3 weeks.
Lordship. Obliged, Lordship.
My pleasure, Lordship. Lordship, I beg to mention item number 53. I'm yet to receive instructions. Lordship, you kindly allot me 2 weeks' time to file my counter affidavit.
Miss So-and-so, learned government advocate for the respondents, has prayed for time for filing of their affidavit in opposition. Praise
Lordship,
aloud. Huh.
I
This
don't-
is matter after 3 weeks.
Item number 12 on behalf of Inhauli. Lordship, you
12.
kindly list this matter after 3 weeks for admission hearing.
Why, what happened? It's been listed for hearing or admission hearing today. So what happened?
She's not giving well.
Okay. Anyone appearing for the petitioner?
Yes, my lord.
Mr.?
Pakin Ritsapo, my lord.
Okay, now your names, please give it later, okay? Mr. So-and-so appears on behalf of the petitioner, while Miss, yes, your good name, your names.
Pichano.
Picha now appears on behalf of
Inaholi.
Miss Inaholi, learned government advocate for the respondents, and has prayed for time for and has prayed for adjournment of the matter since Miss Inaholi, learned government advocate, is not able to appear due to some personal difficulties. In view of the above, list this matter after 2 weeks.
Lordship.
Yes.
My lord, I'm appearing for item number 53. The order is already passed in item number 53. Yes, my lord.
Yes, we'll reflect your presence then. We have already passed an order,
Okay, my lord.
isn't it? 53, we'll just mention that Mr. So-and-so appears on behalf of the petitioner in item number 53. Yes,
And Lordship, I beg to mention item number 18 on behalf of Inaholi. Lordship,
what's happened to her?
Lordship, she's not giving well.
Okay. Miss So-and-so, same order. Okay,
Yes,
Miss
Lordship.
So-and-so appears on behalf of the government advocate, Miss So-and-so, who is said to be indisposed. In view of the above, list this matter after 2 weeks.
Lordship, item number 41 on behalf of Supung Chang.
41.
She's waiting for signature, so Lordship may kindly grant some time to file counter affidavit.
Okay, Miss So-and-so appears on behalf of Miss
Supung Chang.
Sepong Chang, a learned government advocate for the respondents, who mentions that a time may be given for filing of their affidavit in opposition, since she is yet to receive the required signatures. Miss?
Anil Longchar, on behalf of the Petitioners Council, S. Longkumar.
Miss
Anil
Ane
Longchan.
Longchan appears on behalf of her senior, Mr. S. Longkumar,
Longkumar.
learned counsel for the petitioner. List this matter after 2 weeks.
Obliged.
Lordship, item number 50 on behalf of
50, yes.
on behalf of Supung Chang. The state are yet to receive instructions, so Lordship may kindly grant 3 weeks time to file counter affidavit.
Miss So-and-so appearing on behalf of Miss
Supung Chang.
Supong Chang, learned government advocate, has prayed for time for filing of their affidavit in opposition. Mr.
Subhamati.
Samangwati appears on behalf of the petitioner. List this matter after 2 weeks. Yes,
Lordship, item number 19 on behalf of Madam Lucy. Lordship may kindly list this matter after 1 week for admission hearing.
19.
Yes, Lordship.
Who is appearing for the petitioner? Miss
Limanaru.
Lima Naru appears on behalf of the petitioner, while Miss So-and-so has prayed for adjournment on behalf of
Madam Lucy.
Madam Lucy Learned. She's a government advocate?
Yes,
Learned
Lordship.
government advocate. In view of the above, list this matter after 2 weeks.
Lordship, item number 39, similar prayer.
Okay, 39, same order. Okay, who is appearing for the petition item number 39? Okay, so item 39 will just mention
I'm for the
that,
petitioner, my lord.
okay, item 39 will change the names. Mr.
Sendiangar.
Santia Angar appears on
Yes.
behalf of the
Actually,
petitioner,
how much time?
Next week.
Next week.
while Miss so-and-so appears on behalf of Miss, what's her name? You're appearing on behalf of
Madam Lucy.
Madam Lucy.
This
And
is a
has
simple
prayed-
matter, my lord, and it has been kept pending for since 2021. So if this can be the
And
last
has
chance.
prayed for adjournment of the matter. In view of the above, list this matter after 2 weeks. We'll make it 2 weeks.
I'm appearing for respondent number 5. Respondent number 5.
Okay, now in this matter, in view of the above, just before in view of the above, you will mention his name. What's your good name?
Chingmai.
Pardon?
Chingmai.
Chingmen.
Chingmai.
Mr. Chingmen appears on behalf of respondent number 5. Yes,
Much obliged.
Obliged.
Please, Your Lordship, I beg to mention item number 10 and 11. Lordship, I pray this matter may come up on Thursday, 28th of 4th.
why, what happened?
My senior, she has personal difficulties today, so
Yes, heard Miss
wickets or no?
V.K. Chanan appearing on behalf of her senior Miss
Age mommy.
A. Zimomi, and has prayed for adjournment of the matter to which date?
20 Thursday, 24, 2023.
24
Thursday.
2023. Miss
Livika,
Devika
for the government advocate.
appears on behalf of the state government. In view of the above, list this matter on 24, 2023. Yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 43.
So many
We pray for a
adjournments.
week's time.
What's the stage? Admission hearing? Is it?
Yes, we pray for a week's time, Your Lordship. Item number 43.
Yes, who are you appearing for? Or is your name in the cause list? Yes, what's your name, please?
Vivana, Your Lordship, I'm appearing on behalf of my senior, Moa Jamir.
Okay, Miss Vivano so-and-so, appearing on behalf of her senior, Miss Mawa Zamir.
Moa Jamir, Your
Mawa
Lordship.
Zamir. Is it a Miss or Mr.?
Mr. Moa Jamir.
Okay, Mr. Mawa Zamir has prayed for adjournment of the matter for 1 week.
Lordship, I'm for the state.
Mr.
Enangami.
Enagami appears on behalf of the state respondents. In view of the above, list this matter after 1 week.
Much obliged.
Obliged, my lord.
Perhaps Lordships. Lordship, I beg to mention item 16. I'm for the petitioner.
So many adjournments, huh? Yes, 16.
Lordship, I'm making a mention on behalf of Mr. S. Datta.
Huh?
He's he's an outstation advocate. So, Lordship, may kindly fix the matter on 2nd of May.
2nd May.
2nd May, Lordship.
Mr., your good name, please?
Foseco.
Foseco makes mention on behalf of his senior, Mr. S. Datta, senior advocate, who is an outstation advocate and has prayed that this matter may be taken up on 2/5/2023.
Lordship, there's an interim.
Lord,
Kindly let him continue, Lordship.
Wait,
I'm appearing on behalf of respondent number 2, Kanarabing.
Mr.
Pakin Richabu.
Pakuna Chabo appears on behalf of Miss Keme Alin Rongme.
Yes.
Is it?
Sure.
Learned Counsel for respondent number 2 and Miss,
And my lord, I beg to submit. I've not received the affidavit filed by the state.
who mentions that he has not received the affidavit in opposition filed by the state respondents. Miss,
I'm mentioning on behalf of
first
AIB.
of all,
The
Miss,
state has already filed the affidavit.
Miss so-and-so
AIB.
appears on behalf of the government advocate, Miss
AIB.
AIB, Learned Counsel for the State Respondents, and mentions that they have already filed their affidavit in opposition, copy of which is to be furnished to the Counsel for Respondent number 2.
Lordship is the interim. Can I let the interim continue?
In the list is matter after 3 weeks.
Lordship on 2nd May.
Okay, list is matter on 2/5/2023.
Lordship
In
is
the meantime, as prayed for by the Learned Counsel for the petitioner, interim order passed earlier shall continue till the next date.
How do you oblige?
Lordship, I beg to mention item number 48 on behalf of AME.
Yes, what happened?
The state are yet to file affidavit, so Lordship may kindly grant 2 weeks time to file.
All adjournments, no? Yes, Miss So-and-so, Learned Government Advocate, prays for adjournment of the matter since they have yet to file their affidavit in opposition.
Yes, Lordship.
Yes. Then Miss
Lima Naro.
Lima Naro appears on behalf of the petitioners. In view of the above, list this matter after
2 weeks.
2 weeks.
Much obliged.
Lordship, item number 51 on behalf of additional AG LT Sangdam. The state is yet to receive instructions, so Lordship may kindly grant 3 weeks time to file affidavit.
Miss So-and-so appearing on behalf of Miss L. Sangam.
Additional AG LD Sangdam.
Additional LT Sangam, additional AG. For these state respondents have prayed for adjournment since they have yet to receive instructions from the state respondents. Full stop, Mr.
Chingmai.
No?
Chingmai.
Chingmai appears on behalf of the state, on behalf of the petitioners. In view of the above, list this matter after 3 weeks.
Obliged, Lordship.
I oblige.
Lordship, I beg to mention item 44, Your Lordship.
Yes.
Item 44. In
Yes.
this case, Your Lordship, I pray for further 2 weeks' time to file reply affidavit, Your Lordship.
How many times have you prayed for reply affidavit?
Yes. Last occasion I prayed, Your Lordship. Here the petitioner is from Dibrugarh.
Okay.
If affidavit is ready, reply affidavit, but due to some personal difficulties, he could not come, Your Lordship. So
Okay. Well, how much time do you need? 2 weeks?
2 weeks, Lordship.
Heard Mr.
TB Jamir.
TB Jamir, Learned Counsel for the petitioner, who has prayed for time filing of his reply affidavit
Lordship.
to the affidavit in opposition filed by the respondents.
Lordship.
Mr.
N. Longkumar, my ladyship.
N.
Longkumar.
Longkumar appears on behalf of the respondent number
1 to 5, 6.
One-
All the respondents.
Okay, on behalf of the respondents. Okay. In view of the above, list this matter after 2 weeks.
Lordship. Oblige.
My ladyship, I beg to mention item 15.
1/5.
1-5, my ladyship.
Yes.
I pray that this matter may be fixed on 25th. It's a consensus prayer. The counsel from the respondent, has some difficulties to attend today. So we have consented that it may be listed on 25th.
Okay, Mr. N.
N.
Lokumar,
Longkumar. I am for the petitioner.
Learned Counsel for the petitioner, submits that this matter may be listed on 25/4/2023 and that the consent of the respondents, counsel for the respondent has also been taken. In view of the above, list this matter on 25/4/2023.
Obliged, my lady.
Lordship, I beg to mention item number 42.
42.
Yes, Lord. I'm for the respondent, all the respondents.
Yes, so who is appearing for the petitioner? Yes.
H. Makam. I'm for the petitioner, Lordship.
So
Lordship,
what
I
are
have-
you praying for?
I've sent to the authority for obtaining the signature. Therefore, allowed me 3 weeks time to file my reply, Lordship.
Okay, Mr.
H. Makam.
H. Mukam, Learned Counsel for the petitioner, is present, along with Mr.
John, appearing on behalf of my senior counsel, W.R. Muli.
along with Mr. John, who appears on behalf of his senior Mr.
W.R. Muli.
W.R. Modi, counsel for the respondents, who mentions that he may be given time to file the affidavit in opposition. In view of the above, list this matter after
3 weeks, Lordship.
3 weeks. Yes. Any more mentions?
For motion, item number 1.
May I please, Your Lordship?
Yes.
May I please, Your Lordship? Your Lordship, the petitioners, they are all serving as primary teachers, Your Lordship. And as they have common cause of action and the relief sought for is also the same, this petition has been filed jointly, Your Lordship. Now, before I take Your Lordship to the impugn order, may I take Your Lordship to page 18, the Annexure 1.
Yes.
May I read out?
Yes.
This is the appointment order, Your Lordship. Sri H. Dokamba Chang, B.A., and Ted, son of such and such, Chinleman village under Tunsan district, date of birth such and such, as per HSLC admit card, is hereby appointed on ad hoc basis as primary teacher at GPS detail such and such, Tunsan, in fixed pay of such and such, with effect from the date of joining. This has the approval by such and such, government by letter such and such, dated such and such, Vice Sri such and such, primary teacher at GPS Tunsan, resigned with effect from such, appointed against SSA post creation, notification number such and such, Your Lordship. Now, terms and condition. 1. The pay and allowance will be drawn against SSF fund and plan under CSS, and the amount payable for salary will be as per the sanction of the Ministry of MHRD, Government of India. 2. In accordance to the terms and conditions contained in government notification number such and such, the appointee shall sign an undertaking that he or she will undergo PSTC, that is pre-service teachers education, Your Lordship, course within 5 years period, and in the event of failure to obtain professional qualification, his or her service will be terminated. During the period he or she undergoes the professional training, substitute appointment shall not be admissible. And 3, the appointment will be for a period of 1 year from joining, and appointment is purely on ad hoc basis, terminable without prior notice, and does not confer any right to claim regularization, Your Lordship. Now, Your Lordship, the service of the petitioner was extended from time to time, and next page is our last extension order, page 19, Your Lordship.
But have they, just 1 minute, has he or she undergone this PSTE course?
Yes.
They have undergone
Yes,
that?
I'll be coming to that, Your Lordship. So extended from time to time. And page 19, Your Lordship, this is the last extension order. And the name of the petitioner is that serial number 12. Lordship has got it?
Yes.
Now, Your Lordship, so for other petitioners, similar appointment order and their tenure also were extended from time to time, Your Lordship. Now, as per the terms and condition of the appointment, Your Lordship, the petitioners, they all have undergone the requisite training, Your Lordship. Page 30, Your Lordship. Page 30, Your Lordship.
Yes, go ahead.
This is the certificate, the training certificate which they have undergone, Your Lordship. This is in respect of petitioner number 1. And similarly, Your Lordship, in serious annex, Your Lordship, for certificate in respect of the other petitioners, Your Lordship.
Yes.
Now, may I take Your Lordship to page 35? 35, Your Lordship.
Yes.
Now, may I read out? In the interest of public service, the Governor of Nagaland is pleased to notify the mainstreaming of 2290 educationally and professionally qualified teacher as per NCT norms appointed under erstwhile Sarva Shiksha Abhiyan and Rashtriya Madhyamik Shiksha Abhiyan. If Lordship may kindly pause here for a moment, Your Lordship. SSA, and there's another central sponsor scheme, RMSA, Your Lordship. Both the schemes are central sponsor scheme, whereas SSA relates to elementary education, RMSA relates to like secondary education, Your Lordship. Now, presently, both SSA and RMSA, they are merged, and then it is called Samagra Shiksha.
Okay.
Right. So that is why it is the word erstwhile Sarva Shiksha Abhiyan, that word is used, Your Lordship, and Rashtriya Madhyamik Shiksha Abhiyan of 2010 and 2013 batches into the state education cadre with effect from 21/4/2022. In other words, Your Lordship, by this notification, those teachers who were appointed under SSA, RMSA, Your Lordship, in 2010 and 2013, they were en cadre in the state
Okay,
education
right.
cadre, Your Lordship, and they are paid regular scale of pay. And as the petitioners, Your Lordship, they are also appointed under SSA, Your Lordship. They have submitted a representation to consider the case to en
Okay.
cadre.
Yes.
Now, their representation, Your Lordship, page 36, Your Lordship. By this, their representation has been rejected, Your Lordship. Page 36. May I read out, Your Lordship?
Yes.
This is addressed to their. Now, they have formed an ad hoc association, Your Lordship. So in that name, they have submitted a representation for main subject, mainstreaming, and scale of pay regarding. With reference to your letter number dated such and such, I am directed to convey regret on your request for mainstreaming into the state school education cadre, as the condition in your appointment letter states that does not confer any right to claim regularization, and scale of pay cannot be granted as your pay and allowances is drawn against SSA CSS fund, depending on the norms of the government of India. Earlier, those 2010, 2013 batches, Your Lordship, their pay and salary also were paid through the fund, MHRD fund, Your Lordship. Now, Your Lordship, similar matters are also pending here, Your Lordship. Now, the order is from page 6, Your Lordship, the second last page. This is order dated 5/4/2023. By this order, this noble court was pleased to issue notice, Your Lordship.
Okay.
So at this stage, Your Lordship, if notice may be issued.
You are the 2015 batch. Is it?
On different, these are the appointment order.
The one which you read out, appointment
Yes.
order, you're the 2015 batch.
2015,
So you want to say you want to be treated in par with the 2010
10 and 13,
2013
because they were also appointed under SSA.
Okay. And they have been regularized.
Yes, they have been regularized.
The earlier ones.
Yes,
So you're the
and
later one who want to be treated the same as the earlier ones.
Lordship.
Okay. Okay, will issue notice first.
Your Lordship, I'm on behalf of my senior Mr. Yang Gauhati CGC, and I'll be accepting notice for respondent number 5.
Heard Mr. T.B. Zamir,
Lordship.
Learned Counsel for the petitioners. This is a petition filed under 226
Lordship.
of the Constitution of India for issue of the appropriate writ against the respondents. The case of the petitioner is that, okay, it's the same matter. He said, is that the petitioners were appointed on ad hoc basis as primary teachers on fixed pay against SSA vacancy sanctioned post and are presently serving at various government primary/high schools.
Primary
Yeah,
school.
It should be only primary,
Primary
yes,
school.
primary schools. Okay. Under the Directorate of School Education, Nagaland, Kohima. The petitioners were initially appointed for a period of 1 year,
Lordship.
but their services were extended from time to time, and they are still serving as primary teachers.
Lordship.
Full stop. Then on 0209-2022, the Government of School Education, Nagaland, Kohima, notified mainstreaming of 2,290 educationally and professionally qualified teachers as per NCTE norms appointed under SSA and RMSA of 2010 and 2013 batches into the state education cadre, full stop. The petitioners then submitted their representation to the respondents, praying for mainstreaming of their services into the state school education cadre and also to grant them regular scale of pay since they were also appointed against SSA sanctioned post, full stop. However, the representation of the petitioners were rejected via order dated 30/11/2022. Aggrieved by this rejection, the petitioners have filed this writ petition praying for directing the respondent authorities to mainstream the services of the petitioners into the state education cadre and to grant scale of pay as granted to regular primary teachers serving in the Department of School Education. Issue notice of motion to the respondents.
May I please, Your Lordship? Your Lordship, I'm
Returnable.
appearing for 1 to 3, Your Lordship. State respondents.
Returnable within 4 weeks. Miss
Livika for 1 to 3.
Miss Livika, learned government advocate, accepts notice on behalf of respondents number
1 to 3 for the
1,
state.
2, and 3. And Miss
Asikiri for Mr. Yangarwati CGC, respondent number 5.
Miss So-and-so accepts notice on behalf of the
Mr. Younger.
learned CGC, Miss.
Mr. Yangarwati.
Okay, Mr. Young Rigori for respondents number
5.
5. No need to issue formal notice upon the mentioned respondents. Issue notice, notice is to be issued upon respondent number 4.
Lordship.
Okay, through registered post with AD within 3 days, returnable by 3 weeks. List this matter after 3 weeks.
For motion, item number 2.
Your Lordship, item number 2 to 6.
Same order?
This is same order, but here, Your Lordship, they are primary and graduate teachers. In all.
Okay,
In-
2 to 6.
2 to 6, in all, in 2 to
Not
6,
primary, not only primary,
No.
but you have to add
and
graduate.
graduate.
In one, we had just written primary teachers, so you'll do slash
Graduate, yes.
Okay, from 2 to
Oblige.
6. Same order.
For admission, item number 7 and 8.
Yes.
Leadership, if may I take my leadership to order dated 14/3/2023.
Fourteen three.
Yes.
Yes.
Second paragraph, if I may be allowed to read. This is a peculiar case where both the petitioner and the respondent number 4 are appointed in the same post. In that view of the matter, the government advocate is directed to ascertain from the government as to whether the petitioner and the respondent number 4 can be accommodated in their regular service of the government.
Yes.
The instruction should be furnished before this court on or before the next date of hearing on 23/3/2023.
I could not produce that instruction on that day, but the instruction I received is both of them had been accommodated by the department. That is the instruction received.
So is that
in,
true?
In that
Yes.
view of the matter, the case.
I
may
have
be
received a
closed.
copy this morning.
So your prayer has been granted?
My
Is
lord.
it?
Yes.
It appeared.
At the same time, I have also got a relief.
Okay, relief is also. So we'll dispose the WPC.
Very much.
Uh, Yes, this is dated 6 April
Yes.
2020, so it's recent. So who is appearing? Heard Mr.
Ejo. Mr. Ejo.
Mr. Ejo.
A.ZHO.
Okay.
Ejo.
Heard Mr. Ejo, learned counsel
For the petitioner.
petitioner.
In
along
both petition.
Okay, for the petitioners, along with Mr. N. Angami.
K.
learned-
Angami.
K. Angami,
Yes.
learned government advocate, and Mr.
C.T. Jamir,
C.T. Zamir for
respondent number 4, in
for
both the
respondent
cases.
number 4.
In both cases.
Yes, for respondents number 4. Okay. In view of this court's order dated 14/03/2023, wherein this court had stated that the government, within inverted commas, okay, the government advocate is directed to ascertain from the government as to whether the petitioner and the respondent number 4 can be accommodated in the regular service of the government, full stop. The instruction should be furnished before this court on or before the next date of hearing on 23/3/2023, close inverted commas. The learned counsel for the government advocate mentions that the state government had notified on, had informed him on 6th April 2023 that, again within inverted commas, okay, in reference to the above cited subject and your letter dated number so and so, you just copy this whole thing. Okay, this order dated so and so. This whole thing. I'll mark it as asterisk. So and so has been appointed. Okay. The learned government advocate thus submits that since the relief has been granted to both the parties, the state government does not have any further steps to take in this matter. Mr. A. Zo, learned counsel for the petitioner, mentions that the writ petition may be closed since he has been granted the relief prayed for. Mr. So-and-so.
C.T. Jamir.
C.T. Jamir, learned counsel for respondent number 4, also mentions that he has no objection to the writ petition being closed since they both the parties, petitioner and the respondent number 4, have been given their appointments in the said department, that is NPWD, in the office of the chief engineer, engineer-in-chief, NPWD.
Lordship,
Is it?
they are
Yes.
working under the executive engineer. Okay.
Wait. Since both of them have been accommodated by the department.
Yes.
Okay, leave it as that. In view of the submissions made by the counsels for both the party, this court find it fit to close the writ petition since the prayer of the petitioner has been already granted by the state government. In view of the above, WPC number 61 within brackets K of 2015 and
WPC
WPC
133 of 2019.
133
Yes.
slash 2019 stands disposed and closed.
Much obliged.
For admission, item number 9.
Yes.
This, Your Lordship. Your Lordship, pleadings are completed. May kindly let this matter be listed after 2 weeks for admission hearing.
Heard Miss
Shisa Jamir.
Shisa Jamir, learned counsel for the petitioner, along with Mr. Yes, K. Angami, is it? Learned government advocate, who mentioned that since pleadings are complete, this matter may be listed for admission hearing. In view of the above, list this matter after
2 weeks.
2 weeks.
Much obliged.
For admission, item number 13.
May I please, Lordship?
Yes.
My Lord, if this matter can be listed on Thursday, coming Thursday.
Why? What happened?
My Lord, I overlooked the cost list and I found that this was listed in the court only. So if this can be listed on Thursday.
Heard Mr.
Taka Kichu.
Tata Kichu, learned counsel for the petitioner, who has prayed that this matter may be listed on, what's the date, Thursday?
20th
On
20th April.
2023. Mr.
Cynthia
Sandhya
Item,
appears
respondent number 7.
on behalf of respondent number 7, along with
Lordship,
Ms.
I'm appearing for respondent number 4, 5, and 6, Apila Sankam.
Apila Sankam appears on behalf of respondents number 4, 5, and 6. In view of the above, list this matter on 24/2023. Obliged, Lordship.
For admission, item number 14.
Yes, affidavit in reply.
Go on, file.
Have you filed the affidavit in reply?
14, I see the 14.
Last court date,
Lordship, when may be allowed a week's time, Lordship? 2 weeks, Lordship.
heard Mr.
More Jamil, Lordship.
Mo Zamir, learned counsel for the petitioner, who has prayed for more time for filing of their reply affidavit. Mr. So-and-so appears on behalf of respondent number
For
3.
respondent number 4, AG.
4.
Office of the AG.
For respondent number
4.
4, while Miss
1 to 3.
1 to 3
for the state.
appears on behalf of the state respondents number 1 to 3. In view of the above, list this matter after 2 weeks.
Obliged,
Yes.
Lordship.
Much obliged.
For admission, item number 17.
May I please, Lordship?
Yes.
Petitioner counsel, he is in court number 2.
Ah.
So let the matter be listed after listed matter. Matter be heard after listed matter.
Time being, we'll make
Yes.
it a time being matter. Yes.
For admission, item number 38.
Yes, anyone appearing? Item number 38. Yes.
Yes. Your Lordship,
Yes.
with regard to this case, the petitioner, in this case, though there is a vacancy is available, though vacancy was available for the post of deputy director, his case for promotion was not considered in time. Hence,
Wait, the petitioner is what? Working as what? Let's come to the
functional
background.
manager.
Okay, the
Yeah.
petitioner is working as functional manager.
Yes,
Is it functional manager under which department?
Industries and commerce.
Okay. Hmm.
Yes.
Okay. Functional manager under industries and commerce. Yes. Then?
Yes. Then he retired.
Okay, he retired.
Yeah,
When?
before getting promotion.
Okay.
Therefore,
Oh.
he is approaching this honorable court for grant of notional promotion.
Okay, notional promotion.
Yes. After that is promotion after retirement. The
When
main
did he
contention,
retire? When did he retire?
31st October 2009.
He retired on 31st October. Then he prayed for notional promotion from. When did he feel he was due for promotion?
He submitted his representation on 14/11/2008 and 9/10 of 2007. Two representations were submitted to the respondent.
Okay, so he felt he was due for promotion in 2007.
Yes, yes.
Okay. After how many years of service as what? As functional director?
He has been serving for 16 years.
16 years as functional director.
Functional manager.
Manager.
Yes.
Okay. And do you have any rules?
Yes, yes. I've already.
Yes, come to
in
the
the
rules.
petition. Yes. Under Annexure C, page number 106 of the petition. Page 107. Page
106.
Yes, 106 is the Nagaland Industrial Service Rule 1986. And in page 108, Schedule 2.
Wait, we should be on the same page. Let us be on the same page. Now you're saying page 106. 106 is this notification. Index number 1, index number 2. Let me just come to the page. Okay, Nagaland Industry Service Rules.
Yes.
Yes.
In page 108.
Page 108, yes.
Yes, clause B, the last paragraph.
Director of Industries.
Yes.
Joint Director of Industries.
Yes, yes. Deputy Director, the B, Senior Grade 2, Deputy Director or General Manager, DIC. The post shall be filled by selection amongst the confirmed member of Nagaland Industries Class 2, Service Grade 1 listed in serial number 1 to 9, sub-rule 2 of Rule 3, with at least 5 years continuous service in that cadre. So that was the eligibility criteria. But the whole thing depends on the availability of the
Yes.
the vacancy.
Of the,
So-
availability of vacancy, yes.
Yes, yes. So there were 3 vacancy available during those days. There were 3 vacancy available since 2007. One post was created by Mr. Churai Lohe on retirement. He was serving deputy director, and one was created by Mr. Fusezo Angami, managing director, who retired on 31/10/2007. And another person, Mr. Honovi Aye, deputy director, who expired on 29/5/2007. So the petitioner made representation for promotion to the post of deputy director or its equivalent post on 9/10/2007. That was his first representation, page number 142, annexure X. Annexure H, that was his application.
Yes.
And representation dated 14/11/2008, page number 147, annexure J.
Yes.
That was his second representation. And based on his representation, consequently, the joint director forwarded the representation of the petitioner on 25/11/2008. That is in page 148, annexure J1. Page 148, J1. That is
147. Okay, 140, no.
one is typed at
147 is what? Page 147?
yes.
That is last representation. is
Yes,
it?
yes. For representation.
147. These representations were made. Okay, then?
And 25/11/2008, page number 148, J1. J1. Here the joint director forwarded the representation of the petitioner.
Yes.
Again, on 27/11/2008, 2008, the additional director forwarded the representation of the petitioner to the Commissioner and Secretary, Government of Nagaland, which is annexed in J2, page 149. But no response, no DBC was held in this regard. Hence, the petitioner retired from service. The contention is that the
Yes.
petitioner was aggrieved by the impugned letter dated 16/12/15, annexed in Annexure L, page 181.
181. Yes.
Again dated 11/03/2011, regarding review of DPC 1992. That the case of the
No, 181, page 181, and X-ray L is what? This is a reply.
yes. To
What
his
does the reply say? How did they reply? What was their reply?
Page 181, point number 2.
Okay, it would be an act of illegality
Yes.
to retrospectively promote the retiree. So it was rejected.
Yes, yes.
Because they don't want a retrospective promotion.
Yes.
That was their ground. Okay.
Yes.
Okay, then what happened?
Then again order dated 11/3/2011. That is the regarding review of DPC 1992.
Page
105 B1. Connection.
105.
Yes.
Okay.
This was in response to Nagaland Lukoyota case that they could not entertain the case of the petitioner.
Oh, okay.
Again, dated 16/04/2021, under page 104 Annexure B, the government does not find merit in his case.
104.
Yes.
Okay. Oh. Yes, page 104. Huh.
In the first paragraph, the last line, to convey that the government does not find merit in setting up DPC to review the matter. Now, the contention of the petitioner is that petitioner case ought to be considered under the Nagaland Industry Service Rule, which I have already mentioned in the that he has completed 5 years of service as functional manager and is eligible for getting promotion. Until his retirement, his case could not be considered, though 3 vacancies were available. Again, on OM number 220011/5/86, I've established the bracket dated 10 April 1989.
Where's that? Take me to that page.
Page 235, Annexure O.
235. Yes.
Yeah.
Yes,
Under this,
234, 235.
yes, this is with regard to frequency of DPC meeting. Under this, may your lordship, may I please read? Under 3.1, the DPC should be convened at regular annual intervals to draw panel which could be utilized on making promotion against the vacancy occurring during the course of a year. For this purpose, it is essential for the concerned appointing authorities to initiate action to fill up the existing as well as anticipated vacancy well in advance of the expiry of the previous panel by collecting relevant documents like CRs, integrity certificate, seniority list for placing before DPC. DPC would be convened every year if necessary on a fixed date or 1st April or May. The ministry or department should lay down a time schedule for holding DPC under their control, and after laying down such a schedule, the same should be monitored by making one of their officers responsible for keeping a watch over the various cadre authorities to ensure that they are held regularly. Holding of DPC meeting need not be delayed or postponed on the ground that recruitment rules for a post are being reviewed or amended. A vacancy shall be filled in accordance with the recruitment rules in force on the date of vacancy, unless rules made subsequently have been expressly given retrospective effect, since amendment to requirement rules normally have only prospective application. The existing vacancy should be filled as per the recruitment rule in force. So, in the petitioner case, there is no regularity of holding DPC meeting, And so the vacancy was there, and in spite of serving for 16 years, he could not get the opportunity to get promotion. It is the duty and responsibility of the respondent to set up or constitute DPC on time. So on the failure to constitute the DPC on time, the petitioner should not be victimized. For not setting up DPC, though the petitioner was eligible and vacancy was available during that point of time, he has suffered irreparable loss. Under this rule, DPC should convene every year to prepare panelists for promotion, but the respondent did not do, hence the petitioner case was denied. Again, by office letter dated 27/11/08, page number 149. Page number 149. Yes, 149.
Yes.
The additional director has written to the commissioner and secretary, Industries and Commerce Department, Kohima, to consider the case of the petitioner, but did not respond.
Okay, so the
In which-
commissioner secretary did not respond.
Yeah,
Yes.
In which it was suggested for his case and could be considered, but the same was not done. So the petitioner has the right to be considered under this forwarding letter.
Okay, retrospective promotion is what you're praying for, isn't it?
Yes,
Maybe,
yes,
huh?
yes.
Yes.
Again, by OM number 2211/4/98 hyphen
Page, you come to the page
page 166.
166.
Yes.
Yes. What does it say?
67 is more clear. 67.
Okay, this
Yeah.
is the
For
procedure to be followed.
be-
Yes.
Procedure to be followed by the DPC in regard to retired employees.
Yes.
With regard to this, point one, determine the actual numbers of vacancies that arose in each of the previous year immediately preceding and the actual number of regular vacancies proposed to be filled in the current year separately. Consider in respect of each of the year those officers who would be within the field of choice with reference to the vacancy of each year, starting with the earliest year onwards. Prepare a select list by placing the select list of early year above the one for the next year and so on. Doubts have been expressed in this regard as to the consideration of employees who have since retired but would also have been considered for promotion if DPC for the relevant years had been held in time. So, since DPC was not held in time,
Doubts had been expressed in this regard as to the consideration of employees who have since retired but would have also been considered for promotion. Okay, so doubts have been expressed.
yes,
What does that mean?
expressed in this regard
Okay.
as the
Okay, so
consideration.
the matter has examined. What is the conclusion?
Point number 4 is the ministries department are requested to bring this instruction to the notice of all concerned, including their attached and subordinate office.
So what is the main conclusion?
This is considered imperative to identify the correct zone of consideration for relevant years. Name of the retired official are also to be included in panels. Such retired official would, however, have no right for actual promotion. The DBC may, if needed, prepare extended panel following the principle prescribed in the Department of Personnel and Training Memorandum numbers, April 9, 1996.
Where's this memorandum training? April 9, 1996.
Yes.
So you have, if such a matter arises, then you have to follow the principles prescribed in the notification dated 9 April 1996. Do you have a copy of this? If you're reading this, we have to look at 9 April. What does it say? 9 April 1996. What you have just read out doesn't say that you have to consider the retrospective promotion, but it says you have to follow the procedure prescribed by the notification dated 9 April 1996, isn't it? What you have just read. So what does 9 April 1996 say? What is the procedure to be followed?
I don't have the copy.
Then how will we go? How will you convince this court?
The thing is that DPC should be held, but it was not held.
DPC should be held, it was not held.
Yes.
If it was not held, then what is the procedure to be followed? The procedure has to, it needs to prepare extended panels following the principles prescribed in the department notification dated 9 April 1996. Isn't it? Anyways, okay. But does it mention that retrospective promotion should be given?
No, Your Lordship, I'm not seeing.
It doesn't mention
But there is
that. It has highlighted the problem. This is
Yes,
the
yes,
problem.
yes.
And because of that, you have to prepare an extended panel.
Yes.
Okay, so when the DPC said you have to prepare an extended panel, it says,
Yes.
following the principles prescribed in this. So have they followed the principles? What is the principles to be followed? I think you need to clarify this, 1996.
Okay, Your Lordship.
Isn't it? If you're reading this, this is your argument, then what is the principles to be followed? You have to convince this court this is the principles to be followed that has not been followed by the state.
Yes.
It's not clear, then how do you proceed? Anyways, anything
There are
else?
instant cases which has been appended with this petition held by the Central Administrative Tribunal as well as the Supreme Court. That when DPCs are not held in time, the petitioners were granted notional promotion.
Okay, you have those. Huh? Where
Yes,
is it?
yes. And that's in page number 273. Next year,
273.
page 273. Next year, Q3. In the case of RK Kawatra versus Ministry of Defense.
Okay, 273. Let's see what it says. 273, para. Which para are you reading? You want to read the whole page or some relevant paras are there?
No. With para 23. Para 23,
Yes.
page 273.
Yes.
To conclude, after considering the pro and cons, the balance clearly tilts in favor of the applicant. This is the case where it appears that the respondent department did not apply principle of due diligence in the matter of promotion at level of AEs and EEs. The DPC were not held in time. The reason given by the respondent for not convening DPC are not found to be justified when put under judicial scrutiny. The delay in holding DPC led to avoidable delay in the grant of NFU to the applicant. It cannot be stated that such factors are not attributable to the respondent or beyond the control. Such unjustified delay has not been adequately explained by the respondent and is not warranted. And
Read paragraph 24. What is the
respondents
conclusion?
were directed to conduct a review DPC to consider the promotion of the applicant to EE afresh with the respective years of vacancy. 24. The respondents are also directed to review the date of grant of NFSG and NFU based on the review qualifying service of the applicant. PPO may also be revised accordingly and payment of difference or retirement benefits be made as per rules. Action as above may be taken within a period of 3 months from the date of receipt or certified copy of this order.
What are the full form of NFSG and NFU?
Your Lordship, I'm sorry, but I don't have the.
What is the
idea.
full form? What is this? The benefits of NFU and benefits of NFSG. You see the case, one is praying for promotion,
Yes.
revising the date of NFSG and NFU.
I've not seen. I'm sorry, but I have not seen.
If you're saying this is the cases from similar, because this case is for non-grant of NFU, isn't it? And NFSG. Anyways, anything else?
Again, in the case of Nalin Kumar Bhatia versus Union of India, this Brigadier Nalin Kumar Bhatia versus Union of India, 11 February
Yes,
2020.
yes.
Here, I'd like to point out under point 20, page 20. There is no presumption that a decision taken by a person occupying high post is valid. All power vested in the authorities has to be discharged in accordance with the principles laid down by the Constitution and other statutes or rules or regulation governing the field. The judicial scrutiny of a decision does not depend on the rank or position held by the decision maker. So for not giving the opportunity, there are various letters saying that his case cannot be entertained. So this case has been imposed.
Yes.
Therefore, the petitioner is entitled for national promotion to the post of deputy director for not holding DPC on time.
Okay, fine.
When it requires to convene every year or annually.
Yes.
And the instant case 3 vacancies was available and his case was not considered.
Yes.
That is the.
Gist of your matter. Anything?
The petitioner, he has clubbed the cases together. One is asking for a notional promotion to the post of deputy director.
Director, huh.
The other one is for review of DPC, Your Lordship.
Now, there are two cases clubbed together, and the petitioner is the same, isn't it?
No, so he has clubbed his prayer together, saying that he should be given notional promotion to the
promotion,
yes, to the post of deputy director.
Yes.
And the other one is that there should be a review DPC, Your Lordship.
Review DPC is concerning regretting his, isn't it regretting his notional promotion?
But Your
Is
Lordship,
it?
when there is no DPC, where is the question?
Where is
of
the
question
thing,
of
review DPC?
Yes, where is the question of review DPC? When there is no
there
initial.
a DPC held?
No.
Let me ask the petitioner. Was there a DPC held before
is-
your retirement?
That is with regard to promotion to the post of functional manager.
Okay, functional manager.
Yeah.
While ultimately you're praying for deputy, post
Yes,
of
yes.
deputy
No, yes.
manager.
Yes.
So when did you, functional manager, so you were holding the post of what post?
During that
Ah,
DPC.
yes, before the
extension
DPC.
officer. Extension officer. Extension or inspector.
Extension,
yes.
you were holding the post of an extension officer,
Yeah.
and then you wanted to be promoted as
Functional. That was during functional
functional
manager.
manager. So
Yeah.
you wanted to be promoted as functional manager. Okay. So the DPC sat before your retirement and they refused to promote you as functional manager. Is that correct?
That is in the year 1992. Now we now from functional
Okay.
manager to deputy, and in this period, no DPC was held. But why this DPC came into picture is that the Lukayota, the petitioner approached the Lukayota, and Lukayota is directed to review DPC in 1992, and which is not feasible.
Lordship, when there is no vacancy, the question of DPC does not arise, Your Lordship. Lordship,
But he's
yes.
saying that there are 3 vacancies.
That arose only in 2008. Even if there were 3 vacancies also, he is not the senior most. His senior will be promoted to DPC.
Where's your affidavit in opposition?
Yes,
Can you
Lordship,
mention?
yes.
Oh.
Yes, I will read my affidavit in opposition, Lordship.
Or should we admit the
I don't-
petition and fix another date for hearing?
It's a simple case,
Okay,
Your Lordship.
okay.
It
Where's
can
the
be,
affidavit
yes,
in
yes.
opposition?
Page 2, I'll read my affidavit, Your Lordship.
Wait.
Page 2, paragraph 4.
When did you file your affidavit in opposition?
I filed it on 12th of May 2022.
Let's see the
Affidavit on
joinder, wait,
1, 2, and
this is
3.
it.
Yes.
Affidavit in opposition.
Yes.
Filed on 12/5. Yes. Para?
Page 2, paragraph 4.
Yes, let's get
Yes.
the facts
Yes,
correct.
yes.
I think we are confused about the facts.
Yes.
Page 2,
Paragraph
paragraph
4.
4. Yes.
That with regard to the statement made in paragraph 4 of the writ petition, the deponent denied the same and begged to state that in sum and substance, the petitioner's primary grievance in the instant petition is to consider his case for notional promotion to the post of deputy director, albeit misplaced, whereas the impugned letter dated 11/3/2021 and 16/4/2021 pertains to holding review DPC for the year 1992 with regard to the post of functional manager, which was a consequential outcome of the order dated 27/8/2020 passed by the Lok Ayuta without any inherent jurisdiction. The deponent begs to advert to the order of the Lok Ayuta at the appropriate paragraph here in below. In light thereof, it is
Wait,
humbly...
wait.
Yes.
Now, concerning this is for the notional promotion.
Yes.
While as the letter dated 11/3/2021, that is after his retirement.
Yes,
Okay,
Lordship, yes.
16/4/20 pertains to holding review DPC.
Yes.
For the year 1992?
Yes, because the Lok Ayuta has directed the person order directing the respondents to hold a review DPC. So accordingly, Your Lordship, we have
The
given a
DPC
letter.
is 1992.
1992 is with regard to the functional manager. He is
Yes,
questioning
functional
the
manager. Huh?
yes, he is questioning the seniority of another person, Your Lordship, as
Okay.
a functional manager,
Huh.
because at the time of promotion, the petitioner was found to be unfit for promotion.
To the post of
Functional manager.
functional
Yes.
manager.
So
Huh.
his immediate junior was given promotion, Your Lordship.
Hmm.
So he is claiming seniority over his immediate junior in the rank of functional manager, Lordship.
So was he ever appointed as functional manager?
He has been given functional manager, promoted to functional manager in
When?
the year 1993.
1993,
Yes,
isn't it?
yes, yes.
1993. So this does not deal with, this is a 1992 order.
Yes, yes.
So this is different. So in 1993, he has been
Given promotion to
promotion as-
functional manager.
Yes.
Yes, yes.
Okay.
Yes.
Hmm.
So, Lordship, in the light thereof, it is humbly stated that the petitioner has erroneously clubbed these two issues, notional promotion to deputy director and review DPC for 1992 for the post of functional manager into one. Nevertheless, it is submitted that the instant petition seeking notional promotion to the post of deputy director is completely misconceived, as none of the petitioner's juniors was promoted to the said post prior to his retirement, nor was there a DPC held at any point of time considering promotion to the post of deputy director prior to the retirement of the petitioner. Then at page 3, Your Lordship. Yes, para 5, that with regard to such and such, the deponent back to such and such, that all the issues therein are interrelated pertaining to the promotion of the petitioner's immediate junior ahead of the petitioner to the post of functional manager. It is stated that there were 4 candidates who were proposed to be promoted to the post of functional manager, namely in terms of seniority, such and such. Number 4 is Surisha Keduyosa. He is the petitioner. Though proposal for promotion of the first 3 employees were found to be all right, it was observed that the petitioner SCR for the year 1989 and 1990 were very bad. As such, he was not considered fit to be promoted to a higher post. Therefore, promotion was inter alia granted to one Sri O Tem Seau, who was the immediate junior of the petitioner, via common notification dated 26/5/1992. As such, it is denied that the respondent authority acted unfairly or that favorable candidates were recommended or that there were biasness and arbitrariness. 5.2. Regardless, however, and without any prejudice to what has been stated above, it is respectfully submitted that the contention pertaining to the promotion of Sri Otem Saau to the post of functional manager, thereby superseding the petitioner, is time bar. It is settled law that filing continuous representation does not arrest time, and a person aggrieved by any order promoting a junior over his head should approach the court at least within 6 months or at the most a year of such promotion. Therefore, it is too late for the petitioner to be agitating this issue now, which is also not even a part of the prayer in the writ petition. Para 6. That with regard to the statement made in paragraph 12 and 13 of the writ petition, the deponent states that there is no question of retaining the seniority of the petitioner in a higher grade once he has been superseded. This is also clear from clause 3, Roman 2 of the OM dated 9/6/1966, annexure H2 to the writ petition relied upon by the petitioner. The said clause clearly provides that a person considered as unfit for promotion is subsequently promoted shall not take seniority in the higher grade over his junior who had superseded him. As such, it is denied that there has been any ache of biasness, favoritism, arbitrariness, or adamant attitude. Lordship, then come to page 5, para 8.3. However, the matter regarding promotion to the post of deputy director could come to friction. Both the petitioner as well as Sri Otem Saau were released from service on retirement by the order dated 30/9/2009 in terms of the Nagaland Retirement for Public Employment Second Amendment Act 2009. In the list of retired employees enclosed therewith, the petitioner appears as serial number 11 and Sri Otem Saau appears as serial number 7. Then 8.4, nonetheless, it is stated that both the petitioner as well as Sri Otem Saau were granted time-bound scale in the scale pay of Deputy Director as per ROP revision of pay 1999, that is such and such. Sri Otem Saau was granted time-bound scale via notification such and such dated 25/3/2008. As such, their pensions have been adjusted accordingly in that scale. Then page 7, para 10. Page 7, para 10. That with regard to the statement made in paragraph such and such, it is stated that as per the memorandum dated 5/2009, containing the tentative seniority list, the petitioner was not the senior-most functional manager retired. Nonetheless, the representation of the petitioner dated 26/3/2015 was forwarded by a letter dated 7/7/2015 with proper explanation. Consequently, the representation was duly examined and replied by the letter dated 16/12/2015. It is stated that neither does the OM dated 12/10/1998 nor the OM dated 14/11/2014 speaks of any actual promotion or any post-retirement benefit, as already mentioned in the letter dated 16/12/2015, wherein the observation of the PNR department has been provided. The purpose of the SIC OMs are only to identify the correct zone of consideration for the year concerned. Therefore, the representation of the petitioner dated 26/3/2015 is misplaced. 11. That with regard to the statement made in such and such, the deponent stated that both the central government OM dated 14/9/1992 and 25/1/2016 are not relevant for the purpose of this petition. Both the said OMs refer to promotion of government servant against whom disciplinary or court proceedings were pending or whose conduct was under investigation. Such is not the position in the instant case, hence all other allegations are denied. Then, Lordship, at page 8, para 12.2. In addition, clause 2 of the OM dated 15/11/2018 envisages a situation where a government service was not recommended in the first instance by the DPC, but was later recommended by a review DPC. But the government servant has already retired by the time the review DPC made its recommendation. Whereas in the case at hand, as already averred to above at paragraph 8.3, DPC was not held for considering the petitioner case along with others for promotion to the post of Deputy Director prior to the retirement of the petitioner. As such, in the absence of holding the initial DPC, the question of holding a review DPC does not arise. Therefore, Lordship, at page 10, second para. In the light thereof, it is submitted that the claim of the petitioner for notional promotion is a subject matter pertaining to his service condition or service. Therefore, the order dated 27/8/2020, this is the Lok Ayuta order, passed by the Lok Ayuta is a nullity as there was no jurisdiction over the subject matter. However, without any prejudice to what has been stated above, it is also stated that the direction of the Lok Ayuta to submit a representation for holding review DPC is erroneous, as the same is not in tune with what has been provided in the OM dated 15/11/2018, which your humble deponent has already averred to here in above at paragraph 12.1 and 12.2. Be that as it may, the respondent authorities rejected the representation of the petitioner dated 2/11/2020 for review DPC as there was no merit. Lordship, may come to page, this is how we have given justification to the petitioner representation. Page 105 of the writ petition.
Okay, 105 of the writ petition.
Yes, yes.
Yes.
This is dated 11th March 2021. This is subject regarding review of DPC 1992 and consideration thereof in respect of Sheikh Edu. This is the petitioner in light of judgment and order dated 27/8/2020 passed by the Nagaland Lok Ayuta in case number such and such. With reference to your letter number and in continuation to this office letter of even number dated such and such, I have the honor to state that number one, the issue dates back to 1992 when Sri Otem Saau, Extension Officer, was given promotion to Functional Manager ahead of Sri Shekadu Yosa, who is senior to the former as per the NPSC merit list. Two, the out-of-term promotion was given to Sri Otem Saau, Extension Officer, on the decision of the government, which is clearly reflected in the enclosed note sheet dated 21/1/1992. Number three, later in 1993, Sri Shekedu Yosa, Extension Officer, was also promoted to Functional Manager. Four, in the course of time, both Sri Otem Saau, Functional Manager, and Sri Shekedu Yosa, Functional Manager, had applied for promotion to the post of Deputy Director General Manager against the vacancy caused by the retirement of Sri Honivi Aye. However, before the government could initiate any action against the proposal for promotion, the Nagaland Public Employment Second Amendment Act 2009 came into force, by which both Sri Otem Saau, Functional Manager, and Sri Shekedu Yosa, Functional Manager, were released from service on completion of 36 years and 37 years, respectively. Number five, time-bound scale of pay was granted to Sri Shekedu Yosa, Functional Manager, on his personal request and not imposed. Six, both Sri Otem Saau and Sri Shekedu were given promotion on officiating basis and not through DPC. Therefore, the question of reviewing DPC does not arise. Seven, as per the record, denial of promotion to Sri Shekedu Yosa in 1992 was due to the application of the Nagaland Services Discipline and Appeal Rules 1967 and memorandum issued by the Home Department, Appointment A Branch, such and such. In the light of the above, the department do not find merit to forward proposal for review of DPC 1992 in respect of Sri Shekedu Yosa, Functional Manager.
Yes.
Yes.
So you have already been given promotion on officiating basis, isn't it?
Lordship,
You have been given promotion.
yes, yes.
As deputy
Fun-
manager.
Yes.
Functional
How
manager.
functioning. How?
Yes,
Functional manager.
How?
yes. So, Your Lordship, here now the petitioner is questioning, challenging the seniority position of his immediate junior who had been superseded him. After a lapse
Is
of
that the case?
yes,
You have not mentioned anything about that.
yes, all his prayers are that saying that
In your submission which you made before the court,
Yes.
your main point was that after 16 years of
Yes.
service,
Yes.
okay,
Yes.
your case for promotion was not considered
Yes.
because there was no DPC.
Yes.
That's what your submission is, verbal submission,
Yes.
isn't it? But it appears to be, but we have not looked into your written petition,
Yes.
which seems to be a bit different. Here it is concerning the promotion.
Yes. Now the question arises, the seniority with regard to-
Seniority, yes.
Yes, that also have been included in the writ petition.
It's been included in the writ petition, but
Yes,
not in
but-
your submission.
Yes.
In your verbal
because-
submissions made, you have not mentioned anything about the seniority.
Yes. Seniority.
So
I
you're
didn't
not
mention.
aggrieved by the senior, you're not pressing on that point?
No, we'll be pressing because.
You will be pressing?
Yes, yes. I want
Then
to be-
please press,
Yes.
then only we can hear your point.
Okay. With regard to seniority, in the year 19,
See, you come, whatever you have made, the submissions made in your writ petition, you deal with all the points.
Okay.
You have considered and harped on only one point. That is DPC did not sit.
yes,
While you were due for promotion, I think in 2007, there were vacancies. You said there were 3 vacancies
yes,
in 2007.
yes,
And you have been serving For
16.
16 years?
Yes.
And DPC was never held?
Yes.
So you're saying that when vacancies were available in 2007, before your retirement in 2009, there should have been a DPC considering your promotion.
Yes.
That's a point which you raised.
Yes.
Now, when the learned government advocate submits their point,
Yes.
it appears that in your writ petition, there was another grievance
Yes.
which has not been addressed by you, which is concerning the promotion.
Yes.
A DPC was held where you were superseded by someone which you considered junior to you,
Yes. Yes.
isn't it?
Yes.
So are you going to mention something about that?
Yes. Yes. Your
Then
Lordship.
please do.
On 15/5/1992,
Where's
the
that? Yes.
page number 114.
Page number
114.
140.
No, 114.
114.
Yes.
So you're still aggrieved after your pension also concerning your superstition?
Yes, because the respondent is raising that I'm already superseded and I don't have any right to avail the benefit. So I'm pressing this again.
Okay.
There is a lot of representation with regard to his seniority. Yes, I'll list out.
Okay, 114.
Mm. That is the promotion order given to his junior. 113 annexure D. 113 and 114 is the type copy. It's clear. There, number 4 has superseded the petitioner.
Okay, so in page 114, there's an order
Yes.
dated 1992.
Yes, yes.
Okay,
Yes,
where you were superseded
yes,
by this order.
yes.
Aggrieved, you went to Lokayukta.
No, that is only on the after retirement, on the latter part only, to the local yota is, but in the year this 1992.
Aggrieved by this DPC, where did you go?
As the learned council already stated that there was no DPC, it was promoted in under.
Okay.
Yeah, yeah.
So this DPC was never reviewed.
Yes.
Then
On 8 April 1992, the aforementioned order was kept in abeyance.
I'll tell you what, why don't we have heard you, why don't we admit the writ petition and list it for hearing? Okay, some other date. Then we can see. Next week also, we'll be sitting here for 2 weeks. Isn't it? Then let it come for a full hearing. We'll admit the appeal and then see.
Otherwise, Your Lordship, if at all he is aggrieved, he should come on time, Your Lordship, challenging the seniority position. He has not. After a gap of almost 30 years, only he is approaching this court.
So,
And the reason why we have given promotion to his immediate junior is because there was a disciplinary proceeding against the petitioner, Lordship.
All that is there? Is that all that is there here?
No,
You're
what I
not.
have stated, Your Lordship.
You have stated?
Yes.
Your Lordship, with regard to disciplinary action, there is a rule under Nagaland disciplinary
This
rules.
needs a full-fledged hearing, I think. It's not as simple as you appear to mention, because again, we're coming around. So let it be listed for hearing, and then we'll have a full hearing. We'll admit the matter, because I think maybe he has some ground for his grievance. Okay, then we'll see. Heard, Mr.? Yeah, good
Zasi
name.
Soleh. Zasi Soleh.
Okay, Justice Sule. Justice Sule, okay. Learned counsel for the petitioner, along with Miss
V. Shukri.
V. Shukri, learned government advocate for the state respondents. On hearing the counsels for both the parties, this court find it fit to admit the writ petition, and matter is to be listed for hearing When will you be ready? After 1 week, 2 weeks? After 2 weeks.
Obliged, Your Lordship.
Yes. Much better.
For admission, item number 40.
May it bless your lordship.
Yes.
I beg your apology, your lordship. I was in the other court. I'd like to mention, since it mentioned hearings are coming up, I'd like to mention item 45 and 52.
45 and 52, yes.
Yes,
What happened?
I'm representing the state here,
Oh,
state respondents.
yes.
So I may be allowed 2 weeks' time to file my counter.
I think item 44, we have passed an order.
45. 45. 44.
Okay, for item 44, 45 only.
Yes, yes.
Because 45, we have already passed an order.
45.
Okay. Heard, Mr.
I am Tilongcha.
INK Learned Government Advocate.
No. Mua Emchen.
Pardon?
I am Mua Emchen,
Mua
senior
Emchen.
government advocate,
Okay.
representing the state, your lordship.
Heard, Mr. So-and-so.
And my learned friend is for the petitioner.
Okay. We will mention the petitioner first. Heard, Mr.
I am Tilongcha.
I'm T. Longcher, Learned Counsel for the petitioner, along with Mr. So-and-so, Learned Government Advocate for the state respondents. Mr. So-and-so, Learned Government Advocate, has prayed for more time for filing of his...
2 weeks' time, lordship. 2
Okay,
weeks'
has
time for
prayed
filing
for
of the
2
state
weeks'
counter.
time for filing of the affidavit in opposition. In view of the above, list this matter after 2 weeks.
2 weeks, lordship. Your lordship, my 52 also. 52.
Yes. Again, you're going to pray for
Yeah, same prayer, 2 weeks, your lordship.
Mr. So-and-so, Learned Government Advocate, has prayed for 2 weeks' time for filing of the affidavit in opposition. Yes.
Lordship, again, 46.
Item number 46, I
Yes.
think we have passed an order. We have already passed an order in 46. 3 weeks' time has been granted.
Lordship, obliged, lordship.
Yes.
May I please, your lordship? My lord, here I have received instruction that petitioner case is found to be eligible. So
Why?
the petitioner, the department, they are under process to consider their case. So the matter may be closed basing on that instruction, my lord.
Your Honor, here in this case, I'm seeking for regularization as per the OM issued by the government, Your Lordship. And then since the department, the state respondents, they are bound to consider as per the officer, then it may be heard of if Your Lordship
So
is
you're okay with disposing of the WPC now? at this
Yes, Your
stage?
Honor. My
Okay,
prayer is really
because-
made, Your Lordship.
Okay.
So a specific direction may be given to
Yes.
consider the
Heard, heard Mr.
Subhamwati.
Supangwati Wali, is it? Learned Counsel for the petitioner, along with Mr.
E.T. Paphom.
E.T. Bappo, Learned Government Advocate
Yes,
for the
ma'am.
state respondents. Mr. So-and-so, Learned Government Advocate, submits that the petitioner is found to be eligible for regularization as prayed for.
As per the office memorandum dated 17/3/2015.
As prayed for, as per the office memorandum dated, yes,
17/3/2015.
17/3/2015.
Yes.
And that the matter for regularization of the writ petitioner is under active consideration. Okay. Mr. So-and-so, Sungompati Wali, Learned Counsel for the petitioner, submits that in view of the submission made by the Learned Government Advocate, he wishes to withdraw his writ petition. Is it?
Lordship, it may be dispose of as per the submission of
Okay.
the...
In view of this thing, he prays that the writ petition may be disposed on the assurance given by the learned government advocate that his matter will be considered. On hearing the submissions made by both the councils, this court finds it fit to dispose of the writ petition number 120/2021, 2022, with the direction that the state respondents will take necessary steps for regularization of the petitioner as per the office notification dated 17/3/2015. So and so accordingly stands disposed.
Your Honor, if a certain specific time period may be given.
Yes, 3 months, my lord.
Okay, within 3 months. Okay. Yes.
Obliged, Your
Much
Honor.
obliged.
For admission, item number 41.
Matters called out. I think we have already passed an order. Yes. There was one time being matter, item number 17.
For admission, item number 49.
Okay, 49. 49, yes. Yes, anyone appearing for the respondents?
I'm appearing for a petitioner.
Okay, yes, what is the stage?
My lord, I'm appearing for my colleagues.
Counter
Yes.
affidavit.
Yes, my lord, 3 weeks may be granted.
Mr.
Pakinwito, my lord.
Akinri Pochbo, is it?
Pakinwito po.
Okay, so and so appears on behalf of learned counsel, appears on behalf of the petitioner, while Mr. So and so appears on behalf of Miss Inaholi.
Yes,
Is it? Learned government advocate, and prays
3
for
weeks time.
time for filing of the counter affidavit. In view of the above, list this matter after 3
3
weeks.
weeks.
Yes.
Much obliged.
Item number 17.
Yes.
May I please, Lordship? Lordship, here I am the petitioner, Lordship. Now, I was appointed as sweeper in the year 1990. And then in a very brief, Lordship. Thereafter, Lordship, now I'm serving for more than 30 years. And then from time to time, my pay has been increased in a way of consolidated, not in a scale. So I'm here before this honorable court for asking for this pay of scale, at the same time regularization. Why? Because basing on the office memorandum issued by the government of Nagaland. And Lordship, I'll
Dated what? 17/3/2015. Is it? Which notification?
Lordship. That office memorandum is, Lordship, at page, starting from page 18. This is my representation. Page 20, Lordship.
Page 20.
Of my petition, Lordship. This is the office memorandum, Lordship. And then another office
This is
memorandum.
2016.
Lordship.
Yes.
And then another office memorandum is at page 22. I have included in my petition. That is Annexure 6.
And page 22. Okay.
22. These are the two office memorandum on which the work charge, casual employee, contingency were given the opportunity to regularize those who have completed more than 30 years by giving scale of pay as well as regularization, Lordship.
Okay. Oh.
Now, Lordship, here, see, after serving for so many years, I was deprived for giving this a scale. Forget about the regularization. Now, in order to ascertain more clarity, I have applied the list of sweepers in the department through RDI, Lordship. So, Lordship, in that reply, Lordship may kindly come to the page 15 annexure 2. This is the application for information, Lordship, RDI. And then based on this, the department has replied accordingly at page 16. And the figure is at page 17.
Okay.
Now, may I have attention to Lordship? Here, I was appointed in the year 1990. Whereas, as per the list in the department, those starting from serial number 1 to 6, they were appointed later than me, Lordship. Whereas they were regularized. So,
You were appointed in
1986, there is one. Of course, there is-
1990.
that is prior-
Okay,
prior to me.
okay, right.
But after that, there's serial number 2. His CV is 1/11/2014. Appointed, date of training service, date of regularization is 1/11/2014. They are indicated as compassionate, no doubt that one. 3, also same, 15/12/2017. Date of regularization is 15/12/2017. Now coming to 4. Srimati Nokitule, date of joining in service 1/7/2012. That is later than me. And then she was regularized on 18/1/2018. And then 5, Meto Holi, date of joining in service 3/12/2013. Regularization is 22/7/2020. And the last one is 16. This is Cecile Santam. Date of joining in service 7/1/2014. Regularization is 20/07/2020. So what I'm bringing to the Honorable Court is that after those are the later appointee than me, they were given regularization. Now, that is just I'm giving the injustice, Lordship.
Yes.
Now, coming to my service, Lordship, if you kindly turn to my page 13, that is not legible, so I have make a type copy at page 14. So this is the initial appointment order.
Okay.
So I may be allowed to read.
Yes.
In the interest of public service, Sri Birimo Chang, son of Sri Pinikyu, is hereby temporarily appointed as sweeper and posted at STU Hydro Subdivision Tunsang under the establishment of Executive Engineer Hydroelectrical Division Kohima with effect from the date of each joining for duty at a consolidated pay of rupees 450 per month fixed as contingent personnel. So this is my first appointment. Thereafter, I'm being working in the department as a sweeper without any service break. So now I'm getting a little over 5,000, Lordship. Now I'm coming before this honorable court by stating that now within the span of 2 years, I'll be retiring from the service. So I want to avail the office memorandum. So, Lordship, this for the availing, I have requested the department as well as the made a representation to consider my case. But till now, they have not considered.
You have not received any reply?
No reply. At the same time, no scale was given, no sort of initiative for regularization of my service.
Where's the request made by you to the department?
Page 18.
Okay. In 2020?
2020.
No reply to that?
No reply, no reply.
Yes.
Now, I would like to highlight some this office memorandum.
Okay.
So, coming to that page 20, even we are allowed to
Yes.
read from 1:1. This is office memorandum verification of work charge and casual employee follow-up action thereof. Now coming to that, straight to the Roman one. Considerable numbers of the cases of the casual contingency employees are given scale bay, some under ROP 1993 and some under 1919. Casual contingency employees are not covered by the ROP rules 1919 and 2010. Their service conditions are to be guided by the Nagaland Work Charge and Casual Employee Regulation Act 2001. As per provision under the scheme for regularization and observation of work charge and casual employees dated 17/3/2015, all work charge and casual employees shall get the revised pay as prescribed by the government. Second, Roman 2, the department concerned may remove a proposal to the government for those employees who have completed 30 years or more as on 1/1/2015 for regularization by conversion of the post into regular ones personal to them as per OM dated 17/3/2015. 3. The department concerned may revise the wages of the casual contingency employees as per rates fixed by the state government. Why I'm reading is, Lordship, I'm also a contingency appointed personal employee. So I'm covered. What I mean, submission is that I'm fully covered by this case, this office memorandum. Now coming to the next office memorandum as an annexes at page 22 and there are 6. Now, serial number 1, Roman 1, all existing work charge and casual employees of various departments who are enjoying scale pay and who have completed 30 years or more continuous service as on 1/01/2015 will be regularized by conversion of their posts into regular ones, personal to them and subject to fulfillment of conditions as indicated below. So now after that, I would like to read the next page. That page 23, Roman 2. In respect of those work charge and casual employees in scale pay who have completed or will complete 30 years of continuous service after 1/1/2015, their cases for regularization will be taken up subsequently in 2 pages as on 1st July and 1st January every year. The procedure and terms continue will be same as laid down in this office memorandum. Now the third, the existing scheme for regularization of work charge employee against normal vacancy is being modified and the quota for work charge employee stands enhanced from 50% to 67% for the next 5 years, effective from 1/01/2015. This existing scheme will also be applicable for casual employees appointed in full-time basis. So why I'm reading is that I'm fully covered by this office memorandum because I'm working in the department without any service break for more than 30 years. And then, Lordship, why I'm saying this that in the state respondent has already filed the respondent, and then in their affidavit, in the counter affidavit, they have stated that I'm not covered by this office memorandum. That is why that is they are saying that I'm a fixed pay employee.
Okay.
But whereas I'm saying that I'm a contingency employee, and then as I've read it out in the office memorandum, it's contingency employees are also indicated in the office memorandum. And then not only my regularization, but even the scale of pay, till now they have not given me. And then this in so many such similar cases has been filed before this honorable court, and then all the case has been disposed of favoring the for consideration of scale of pay or either regularization. So
okay, give me 1 or 2 judgments of this court.
So many cases has been disposed of by this honorable court in lieu of this office memorandum, asking the state respondent to consider. So this is the single one similar.
So is this exactly similar to your case?
Yes,
He has
office
been
memorandum. Yes,
appointed as what?
this was appointed as a work charge
Okay,
level
as-
with consolidated. May I,
Yes.
wait, Lordship, it's only 2 pages.
Yes.
The petitioner was appointed as a work charge labor with consolidated pay of rupees 300 per month with effect on 2021-8-985 by order dated such and such issued by additional executive engineer PWD Gauhati division. A year later by another order such and such, Gauhati division appointing the petitioner as work charge but with a scale of pay. Since her service was not regularized, she approached the department for same, but in spite of verbal assurance, her service was never regularized. In the meanwhile, White Office order dated 7/5/2019 issued by the sub-division officer. The petitioner was released from service attaining age of 60 years in terms of such and such, such and such. Since her service was not regularized, the petitioner could not enjoy pension and pensioner benefit. Therefore, she submitted a resignation to the engineer housing, such and such, requesting for regularization of her service for the purpose of pension and pension benefit. Her resignation did not receive positive response. Therefore, she here before the court praying for appropriate direction, directing the respondent to regularize her service so that she may enjoy pension and pension benefit. The Learner Council such and such that petitioner retired from service after serving 30 years that do with a scale of pay. Therefore, she was very much entitled to regularization of her service in terms of office memorandum AR 3 General 201/2009 dated 17/3/2015 issued by BNR Department Administrative Reform. This is a notification which I have read, Lordship. So accordingly, in view of the submission, such and such, that contains the instruction received by her and also the provision office memorandum mentioned above, this revision is disposed of with the direction the case of the petitioner be considered and disposed of with a period of 3 months, so, and that she may enjoy pension with this revision for disposal. So this is only one petition.
Here, the
disposed.
government is saying her matters under consideration, isn't it?
Pardon, please.
Here, the government is saying that her matter in this case is under consideration by the state government.
Maybe, but what I'm saying is that this also comes under the shelter of this office memorandum,
Okay.
2015.
Mhm.
So the same privilege may be given to the present petitioner here before the National Court, as stated that petitioner is in the verge of retirement, now almost served for more than 30 years. Now almost 30. While filing this petition, he has already completed more than 30 years. Now almost 3 years.
Yes.
Now within one half year, she will be going from service. So before that, I'm approaching the National Court for this basing on this office memorandum.
Yes.
That is my whole submission.
Got it. Oh.
May I please, Your Lordship? My Lord, here the petitioner is saying that they are covered by Office Memorandum 17/3/2015. Yes, the petitioner is covered by this memorandum, but they are not eligible under this. Why?
Why? Huh?
Your Lordship may kindly see that relevant para. Relevant para A1. Well, here it says that all the existing work charge and casual employees of various departments who are enjoying scale of pay and who have completed 30 years or more continuous service as on 01/01/2015 will be regularized by conversion of the post into regular one personal to them and subject to fulfillment of condition as indicated below. Here, who are enjoying scale of pay, it
Yes.
says that. So here the petitioner, though the petitioner has served for 31 years, but he is still in fixed pay. They're not enjoying scale of pay.
Okay. Oh.
So as per the memorandum, it says that those who are enjoying scale of pay and completed 30 years. So until and unless the petitioner fulfill these criteria, the petitioner case cannot be considered. That is the main
Okay.
submission, my lord.
Uh-huh.
And secondly, so as per this OM, the petitioner is not eligible. That is why the state government could not consider the petitioner case. Secondly, the petitioner, they say that they have applied for RDI and they have received the reply. In that petition, they have mentioned that
Yes, the RTI. huh?
some juniors have been regularized. Superseding the petitioner, some juniors have been regularized. Here, the nature of appointment is different, my lord.
Okay.
Because here in the RDI list, those who are, at least the sweeper mentioned in the list are work charge employees. And the petitioner, they were appointed on contingency basis. In that appointment order, it clearly says that
Yes.
She was appointed on contingency basis. So benefit, because the nature of appointment is very much different. So the benefit granted to the workers employees cannot be claimed by the contingency.
Okay. Now, what is
So,
the difference, work charge and contingency
my lord,
basis?
in that definition, work charge definition has been given in that work charge uh, Nagaland court. I forgot the section, but it is mentioned that any employees engaged without sanction boss under work charge establishment, they are called work charge employees.
Okay. And the
And the
present,
contingency employees,
uh,
there is no specific definition in that act, and in no act the definition of contingency has been
then if it's
given.
not defined,
But as per the dictionary meaning,
uh,
the contingency employees are someone who works for an organization without being hired as their employee. Contingency workers are not employees and therefore do not receive the same rights and benefit as permanent employees. They're not the employees. Contingency employees.
but she has been employed for 30 years.
31 years.
31
Yes.
years. And they've used the term contingency.
Yes,
So
ma'am.
where's the appointment order? Just come back to the appointment order.
Page 14. Type copy is page 14. Appointment order is page 13, but type copy is 14.
Typed orders, page 14.
Yes.
Ah.
In the interest of public service, Session Sir is hereby temporarily appointed as
As
sweeper.
contingent personnel.
Yes.
Yes.
No, Lordship. See, because of that, I'm approaching this honorable court for scale of pay as well as regularization. They are not giving me scale of pay. That is why I'm approaching this. My prayer number one. Second prayer is that since I have completed 30 years, I'm again asking to put this honorable court for regularization. Basing on this office memorandum, as I have read it out clearly. See,
Where's that contingent term mentioned in 2015?
this is, if you lordship may kindly come to this, the 2016 memo. Office memorandum,
2016, yes.
page 20.
Hmm.
See, as I read out, may have a lot.
Yes, where's that portion?
Considerable numbers of cases of all casual / contingency
Contingency
are given
employees,
scale of pay.
yes.
Some are under ROP 1993 and some under 1999. Casual / contingency employees are not covered by the ROP rules 1990, 99 and 2010. Their service conditions are to be guided by the Nagaland Work Charge and Casual Employee Regulation Act. So when we are covered by this service condition are guided by this Nagaland Work Charge, I'm eligible.
Yes.
As per the provision under the scheme for regularization and absorption of work charge and casual employee, dated 17/3/2015, all work charge and casual employees shall pay the revised pay as per prescribed by the government. So I'm denied, Lordship. Now coming to that, the third, I'll not read the second portion, but the third one. The department concerned may revise the wages of the casual contingency employees as per rate fixed by the state government. So here, the office memorandum is very clear. It indicates both the casual contingency employee. Now I'm the contingency lordship. So I should be covered by this. If the word contingency is not mentioned here, I'll not claim for that. And then see, as I stated, the nature of work. Just say, bring the relevancy, sweeper in the department. I'm doing the same service. And then without service break, I'm working for more than 30 years. So there are huge injustice.
Okay. An extra one. There's, wait, just a sec. In the first paragraph, okay, this memorandum dated 2015, the department-wise position of verification report is enclosed as an extra one. What is an extra one? The first paragraph. The department-wise position of verification is report is enclosed in Annexure 1. What is this report? The first paragraph, page 20.
Page 20.
Because the following action may be taken by the department based on the report of the verification committee. So this verification report is what? Annexure 1. You see, it's based on this verification report that the following conditions have been enclosed.
Yes,
So I want to know whether this verification report will be the report of the employees,
Might be.
isn't it?
Might
Where
be.
it will be mentioned casual, contingent,
Yes.
isn't it? It should be mentioning that. So where's this verification report? You see, your documents should be complete so that we can have a clear picture.
My lord, here in regard to revised pay,
Hmm.
earlier in the appointment, she was appointed at fixed pay of rupees 450.
Hmm.
Now he's getting 5,000.
Yes.
5,000 something, I think. So time to time, state government has been revising the pay of the fixed
Revising
pay.
the pay,
Yes.
huh?
And the granting of scale of pay, it is under the domain of the state government. It is the discretion of the
Yes.
department.
Yes.
So for granting of scale of pay, there is no scheme or policy as of now. Only for regularization. This OM is for regularization. So until and unless the petitioner is enjoying the scale of pay, then and completed 30 years, then as per this memorandum, case cannot be considered.
See, here it says their service conditions. That means the service conditions, I'm reading this thing, that small one, okay? Second, third para of page 20. Let's understand this properly. The service conditions of casual and contingency employees. So you come under the contingency employee, okay? Their services are to be guided by the Nagaland Work Charge and Casual Employees Regulation,
Yes.
Right.
isn't it?
Right.
Yes.
2001.
Yes.
Now, as per the provisions under the scheme,
Hmm.
that is the 2001 scheme,
Yes.
okay, dated as per the provisions under the scheme for regularization and absorption of work charge and casual employees. So when we say work charge and casual employees, it will also include contingency employees.
Yes.
Isn't it?
Yes.
Dated 17/3/2015, all work charge and casual employees shall get revised pay as prescribed by the government.
Yes.
So is she getting the revised pay?
No,
No.
I'm not giving the scale of pay. That is why I made
my
a
lord,
representation.
revised pay means
Revised
every
pay
area
is not scale of pay.
Yes.
Revised pay.
She was getting
See, I'm entitled for at least for scale of pay.
Okay.
Because
Scale of pay. So you want a scale of pay.
Yes, scale of pay.
Okay. But this order dated November 2016, the first para does not mention anything about scale of pay.
Yes.
It mentions revised pay, isn't it?
But in the first two lines,
Yes. So where does the revised pay come here? Just show me.
in the first two lines, see here somewhere indicated about the scale. Considerable numbers of cases of the casual contingency employee are given scale pay.
Yes.
Some under such and such.
Lots of cases they have been given.
But in my case,
Huh?
I'm not being given the scale of pay. That is why I agree for that.
See, considering number of cases of casual employees are given pay, so they have been given pay.
Scale pay.
Some under ROP 1993 and some under 1999.
Yes.
Okay, so some of them are not. They are not covered under 1999 and 2010 ROP rules. Okay, so because they are not covered under this, Their services are to be guided by the 2001. So what does 2001 say?
So this Nagaland work charge and casual employee
Yes.
Act, under this, who are working as work charge,
Yes.
this office memorandum has been issued for the benefit of the work charge. Because by subject itself, it's very clear. Verification of work charge and casual employee follow-up action thereof. And then in the 2015 also, scheme for regularization and observation of work charge and casual employees and revision of pay wages. So if your lordship may turn to that 2015 notification,
Yes.
the subject itself is a very clear indication. Page 32.
Yes.
Here, scheme for regularization and observation of work charge and casual employees and revision of pay and wages. So here the petitioner is entitled for this scale of pay as well as for this regularization of in the service.
Yes, so your main contention is regarding the contingent employee. I think that is your main contention.
Yes, my lord. The state government is not saying that he's not covered under this OIM. He's covered.
If he's
But
covered, then
he's not eligible because the condition laid down in that office is that the petitioner is not fulfilling any criteria mentioned in that.
what are the
office.
criteria?
Because scale of pay.
Oh.
First, the petitioner should enjoy the scale of pay.
So she's
Yes.
praying that give me a scale of pay.
Yes, that granting of scale of pay, for granting of scale of pay, there is no office memorandum, there is no scheme, there is no policy. It is
So how do you give them the scale of pay then?
It is purely depend upon it is the discretion of the department. So it depends upon the financial position and all.
Okay.
It is-
So now this person says, so that I can endure to 2015, give me a scale of pay because I've been in service for 30
31
years.
years.
Isn't it?
More than 30 years.
Oh, more than 30 years,
And then,
31 years.
As my lender friend has admitted, I'm covered. When I'm covered by this office, I should be given the privilege, that facilities.
That revised pay is already given because earlier from 450 it has been revised to 5,009. Now the petitioner is getting 5,000. Time to time, the state government is revising the pay of the fixed employees, my lord.
So there should be a criteria as to how do you give a person a scale of pay. There's nothing like that concerning giving you a person a scale of pay.
See, as per this office memorandum,
Huh.
those who have completed or served more than 30 years
Should be given pay scale.
should be given a scale of pay as well as the regularization. And then a department will form a kind of a committee, and then it will forward the matter case for regularization. It is clearly indicated in the office memorandum.
Okay. Yes, heard. Mr.
S. Temjen.
S.
Temjen.
Temjen, learned counsel for the petitioner, along with Mr.
E.T. Paphom.
A.T. Pakum, learned government advocate for the state respondents. This is a petition filed under section 226 of the Constitution of India. For directing the respondents. Where is your petition? For directing the state respondents to consider the representation of the petitioner for scale of pay and regularization of her services as per the notification, as per the office memorandum, okay, cancel notification, as per the office memorandum dated 9th November 2016 and 17th March 2015, issued by the Government of Nagaland Personnel and Administrative Reforms Department, Administrative Reforms Branch. Full stop. The case of the petitioner is that the petitioner was temporarily appointed as sweeper and posted as at SDO within brackets Heidel subdivision, Twensang, under the establishment of executive engineer, hydroelectric division, Kohima, wide order dated 9th July 1990, with a consolidated pay of rupees 450 per month as contingent personnel. Thereafter, her pay was increased from time to time, and the petitioner's salary at present is enhanced to rupees 5,000 per month. That the petitioner has now completed 31 years of service, continuous service. However, her representation for scale of pay and regularization in service has not been considered till date. Full stop. Mr. So-and-so, learned counsel for the petitioner, submits that as per the government notifications, that is office memorandum dated so-and-so, those two, okay? The instant petitioner is clearly eligible for scale of pay and regularization, since she has clearly completed 31 years of service. Further, she had requested for information under RTI Act 2005 with regards to details of the total number of grade 4 sweeper employees who were regularized. And as per the reply that she received, 6 numbers of employees had been regularized while the date of joining service, not 6, make it 5, okay, it's 5 number, while the date of joining service was after she had been appointed. Therefore, the petitioner is entitled to be given scale of pay and be regularized as per the mentioned office memorandums. Mr. So-and-so, learned government advocate, on the other hand, has submitted that in terms of the office memorandum dated 17/03/2015, the instant petitioner is not, the case of the instant petitioner, okay, is not applicable since the work charge and casual employees required to be enjoying scale of pay and who have completed 30 years or more of continuous service as on 01/01/2015. In the instant case, the petitioner is not enjoying any scale of pay. He further submits that the instant petitioner, the appointment of the instant petitioner is as a contingent employee and not as work charge employee, and therefore cannot enjoy the benefits as per the office memorandum dated so and so. Having heard the submissions made by both the parties.
My lord, sorry for interrupting, my lord. In regard to granting of scale of pay, and till that there is no office memorandum or the scheme.
Okay.
So in absence of those scheme, the granting of scale of pay cannot be considered. That is
Okay.
the
The learned government advocate also mentions that with regards to granting scale of pay, so far there is no office memorandum as to the eligibility. Okay.
Yes, yeah, for granting scale
for
of pay.
granting scale of pay, and it is in the discretion of the concerned departments for granting the scale of pay to the employees. I think I will make it a CAV. Let me just consider your points.
Okay.
Now, tell me if is there any decision of this court concerning this matter previous?
Lordship, if Lordship may allow.
You're saying there are many decisions.
So that I can again submit one division bench, where
Okay.
in that division bench judgment also, even the contingency is also covered by 2015. That I may be allowed to submit in due course of time because I
Give a copy of the judgment to him also.
My
Should-
lord, the judgment
should-
which the petitioner counsel has submitted, that one also, the petitioner was enjoying scale of pay.
Oh.
In that
Yes.
So,
So,
until and unless,
can you give me a little clarity on the scale of pay? You see, how have they been granted? And anyways, okay, I will make it a CAV, or should we fix a short date, maybe end of this week, where we can discuss their judgments?
Lordship, we have placed before
Yes,
Lordship.
yes. Okay, now, before we say the submission of the Learned Government Council, before that, okay, the Learned Council for the petitioner, in support of his submission, has cited the decision of this court in, yes, in Zovi, Sugzu and others versus State of Nagaland and 7 others, WA number 6/2022, dated 17/02/2023, very recent, and Srimati Lobini versus State of Nagaland and others, case number WPC 29/2022, dated 05/05/2022. Okay. Yes, in this, what is your main point?
There also, the court has given that even the contingency are also eligible, are also covered by that the office memorandum.
Okay.
my lord, here covering is different and the eligible is different.
Yes, yes, I've got your points. I
Yes,
think
madam.
I've mentioned your points clearly.
Yes, madam.
Okay, let me consider your points, okay, and come to, I'll make it a CAV so that I can be given some time to consider your cases. Okay. Heard Mr. So-and-so. Okay, both the parties, okay? And matters reserved for order.
Much obliged.
Yes.